I'm back outside the offices of Rockstar North here in Edinburgh today for what will be the next critical chapter in this saga that has followed the firing of 34 employees for what this company labelled as gross misconduct, what those fired employees, all of whom were union members, call union busting. Today you're going to hear how these union members fared in their first skirmish against Rockstar in court, as both sides laid out at least part of their case for all to hear, including me. I watched the whole thing remotely and we're going to take you through that process step by step. We're then going to examine the evidence that's been submitted by both sides in person for ourselves, taking a look at one particularly serious claim made by the company that two of these fired employees had discussed a quote-unquote top secret unannounced feature of a game currently in development at the studio. We'll show you what they said, word for word, and you'll then be able to draw your own conclusions as to whether that's a fair description of what was discussed. You'll also hear the story of one union member who was fired by Rockstar for sending a single 15-word message on the Discord in which he revealed that there wasn't any crunch happening on his team. Later on, I'll sit down with some of the fired employees to talk about how they're feeling immediately after the hearing had wrapped up. And finally, we're going to drill into the judge's decision itself. Why was that ruling made, and what did she have to say about Rockstar's conduct here? This is a hugely significant moment for both the union and for the company, and we think it deserves some in-depth reporting. As I stand here, we're about 90 minutes away from this case appearing in court for the very first time. Now, this isn't going to be the final hearing. We're still a while away from that. UK courts are incredibly backed up right now. But instead, this is what's called a preliminary hearing. But for the employees who've been fired, or at least the 31 of them who live here in the UK, these next 2 days are going to prove incredibly important. And that's for a couple of reasons. Reason number one, we're going to hear from a judge as to whether or not something called interim relief is required. What does that mean? Well, to put it bluntly, the people who've been fired from Rockstar, they're no longer getting a paycheck, and yet presumably they're still going to need to make rent at the end of each month. It's up to the judge to decide on whether or not these union members have a strong enough case here, or at least the potential for one, that in the meantime Rockstar could be forced to keep paying them until that final ruling happens. Now, importantly, the judge is not being asked here to make any kind of final decision on the validity of these dismissals. That's going to happen later on. Instead, it's about whether or not they think right now, in this moment, that there's a strong likelihood that the main case will prove successful when it actually does get heard. It's an important distinction, and one we'll talk about a bit later on. And reason number two that this preliminary hearing matters so much is because Rockstar, for the very first time, is going to have to show at least some of the evidence that it's collected in order to justify these firings that it's made. We've seen basically nothing from the company so far, aside from a few vague accusations made to the press. So what evidence does Rockstar actually have, and will it prove enough? If you watched our previous video on this story, you'll remember that a Rockstar insider shared some of the messages from this union Discord that they claimed contributed to an investigation into the workers having taken place. However, we still have almost no idea of what the company then uncovered as it trawled through the weeks, months, perhaps years of Discord messages as it began to build a case against these union members. Last month, Rockstar told IGN that the fired employees had leaked confidential information, including, and I quote, specific game features from upcoming and unannounced titles. They also mentioned something about a games journalist having been in the Discord as well. It's finally time to get a sense of what Rockstar has to back up these allegations that it's made, and crucially, what the British courts then make of this decision to fire more than 30 employees in this way. Okay, so the preliminary hearing isn't taking place in a physical court. It's all happening remotely over the course of both today and tomorrow. And although I can't show you any of the footage of what I'm seeing on screen here, I can tell you all about it and share some of the evidence that gets submitted. And yeah, things are about to kick off in 25 minutes now. It gives me a little bit of time to tell you about one more detail. The barrister who stepped forward to defend the union members in this case. His name is Lord John Hendy. Now, Lord Hendy has been a barrister since the early 1970s and is considered one of the most senior names in the United Kingdom when it comes to employment law. In fact, one legal magazine has described him in the past as the barrister champion of the trade union movement, having represented the National Union of Mine Workers during the miners' strike, as well as many other unions over the decades. He was even a part of the Leveson inquiry, representing the NUJ and questioning Rupert Murdoch himself. The Rockstar employees have a huge voice fighting on their behalf here. All right, it's now mid-morning and we've taken a break from the hearing. In fact, we were only live for something like 40 minutes, I think. Maybe not even that. Basically, what's happened at this stage is the judge and the legal representatives from both Rockstar and the union have all introduced themselves and together have agreed that the judge is going to go away and read a set of documents in order for the rest of the hearing to carry on this afternoon and then tomorrow. Now, when it comes to those documents, even just on the witness statements, on Rockstar's side of things, that's something like 20 pages, but from the union, we've apparently got somewhere in the region of 250. So there is not an expectation here that the judge is going to read everything. Again, this is not the full hearing, it's just a preliminary one in which she's going to need to rule on whether or not this interim relief needs to be granted. All right, as you can tell, it's now the end of the day and it's time to catch you up on what's happened so far. Really, the vast majority of today's part of the hearing has been about Lord Hendy making his argument on behalf of the Rockstar union members. He started by coming back to this definition of gross misconduct. He looked at this in two different ways, one of which was the way in which the company itself, both Rockstar and also Take-Two, how they define gross misconduct in their own internal materials, and the sort of procedures that they describe should be in place for their employees if they come up against these charges. Really, the big things to note there were the fact that in the employee handbook, for example, Rockstar talks about things like a disciplinary hearing needing to take place and how employees would be able to bring a companion with them to any interviews that would need to happen as part of the investigation. Certain steps in this process that precede the termination and this charge of gross misconduct. To quote him directly, when he's talking about the employees, they didn't even know an investigation had taken place. He then jumped over to the common UK law definition of gross misconduct, where he pointed to language like willful behaviour being a requirement for that charge, that an employee would need to deliberately flout the contract that they had with their employer, and said that for this immediate dismissal to happen with gross misconduct as the charge, you would need to be able to prove that that the intent was there. And after establishing these definitions, Lord Hendy went on to argue that this central allegation of gross misconduct was, and I quote, merely a smokescreen designed to enable the company to carry out the firings it just wanted to do anyway, and that in his mind they amounted to the mass execution of the union members who were affected. That is the sort of imagery he would come back to time and time again, and he was doing that really to make this point that he believed that the firings and the way that they were handled, the whole thing was orchestrated to serve as an example to other employees at the studio who may have thought about joining the union or were already members. Lord Hendy disputed the fact that any confidential information had been leaked by the union members, and then spent a lot of his argument going through the witness statement of Jennifer Colby, the studio director at Rockstar Games, and essentially putting her words next to the actual posts from the Discord that had been submitted by Rockstar as its evidence. And we'll talk about these posts in a bit more detail later on, because we're going to go and look at the evidence ourselves. But something else came up that I thought was really interesting. Lord Hendy also pointed to the second witness statement provided by Rockstar Games. This one comes from Charlie Kinloch, the director of Human Resources, who details how Rockstar actually gained access to the Discord server in the first place. So, as we found out in our previous reporting, complaints had been made in early October, which led to an investigation into the Discord taking place. And Kinloch claims in that statement, on the 7th and 9th of October, 2 employees based at our Lincoln studio separately contacted me on Slack to report concerns about other employees' improper use of Discord. To assist with my investigation, one of the employees who had reported their concerns offered to share their login credentials for the Discord server, giving me access to see the relevant messages. Now, the problem with this, says Hendy, is that even if we put this charge of gross misconduct to one side and you accept the idea that Rockstar's evidence supports those claims, something that Hendy certainly does not. But even if you do that, that was not the only discussion happening in this union Discord. Hendy argued that Rockstar had clearly viewed trade union specific discussions going back years because, well, some of the posts they submitted as part of their evidence go back to at least 2023, and also very recently, in fact, just a day before Kinloch is meant to have joined this Discord server, there were discussions happening there about the fact that the union had just crossed this all-important 10% threshold that would allow them to potentially apply for statutory recognition. He referenced posts that union members had made about the fact that they'd be going public in 2025, that they'd reached 180 members, and that time and time again they talk about this 10% threshold. And he said, and I quote, "They clearly, this being Rockstar, knew what the union was doing and that it was getting stronger." He argued that this was in fact the reason for the firings taking place. And then he goes back to that imagery once again of mass executions and the fact that not only did these firings of 34 employees take the total number of unionized members below the threshold, it also removed key union activists, and again, it served as an example to anyone else who was watching. Finally, he directed the court's attention to the way in which the firings were handled on the day itself, describing it as a remarkable curiosity that all 30+ employees needed to be dismissed one after the other in the space of about 6 hours. There were no disciplinary hearings scheduled, there was no full reason given for why this charge of gross misconduct had been given, and ultimately he argued that this was about humiliation and again about sending a message to any other Rockstar employee who was thinking about joining a union at some point in the future. Okay, so that was today. We're going to hear more of Rockstar's argument tomorrow. But before then, I want to catch up with the IWGB and just find out how they feel this first day in court has gone and what they make of some of the evidence that they're now starting to see for the very first time. Hey Jamie, how's it going?
Yeah, no, I'm good, thank you. It's been really quite something, and also quite almost cathartic to kind of finally see it kind of out there and to kind of see, I think, the irrefutable injustice and irrefutable kind of arguments made today.
Yeah, I mean, it's been a long time coming that some actual evidence is available to discuss and debate, right? Like this is, up until now, as far as I understand, even the union hasn't had a very clear idea of exactly what proof was going to be offered and how gross misconduct was going to be sort of characterised here.
Yeah, I think we saw that today in the hearing as well. I think one thing that Henry was saying is that there were times when we've kind of seen the sifting sands of what kind of Rockstar have said and what Rockstar have been accusing people kind of publicly or privately. He also kind of raised the question that, you know, perhaps Rockstar have taken so long to produce any evidence and then have very kind of patchy evidence when they did, because they were retrospectively making up the case, which I think is one of the interesting arguments that came out today. There were some key details as well. I remember there was one point that came out that the fact that despite the fact that Rockstar have said this was a public server, they had to impersonate a Rockstar employee or use the account of a Rockstar employee to even gain access to it themselves. So just the fundamental inconsistencies. It's been nice to see a barrister just have a couple of hours to lay those out.
On to day two, where we just heard the majority of the submission from Rockstar, being represented by a barrister called Andrew Burns, and he took a very different sort of approach to the one we heard from Lord Hendy yesterday, and it was really much more technical. A lot of his submission was about defining what the court should mean when it says trade union activities, and really just disputing the idea that the discussions happening in this general chat of the Discord do actually fall within that definition. In fact, to quote him directly, he says, "Merely participating in the Discord is not an activity of the union." This is a point that he kind of kept coming back to. He argued that it's not really enough for the communication that members are making to simply be in support of the IWGB, of the union, or even to be aligned with them. It needs to fit a certain kind of parameter that's narrower than that. And then finally, on the sort of general points made about the messages, he did bring up the idea that for them to be valid trade union activities, these messages would either need to have been sent outside of working hours or within an agreed time that had been made between the union and Rockstar. And because that agreement has never happened, the union isn't recognised yet, he sort of broached the topic that if any of these messages happened within working hours, well then they are not valid trade union activities. This didn't really get argued fully, but I suspect it's going to be something that comes up again when we get to the final hearing. Now, on the idea that this Discord was a public forum, which is something we've heard from Rockstar a few times now, he touched on a few things. First of all was the idea that there was a journalist, and in his words, lurking on the Discord. This is in reference to a man called Scott Allsworth. Now, Scott Allsworth is a few different things, but one of those is certainly a game writer or narrative designer who has spent more than a decade working for Bohemia Interactive on games like Arma 3 before founding a small co-development game studio of his own called Cerberus Creative. He's also an elected representative of the IWGB's Game Workers branch, which is the reason he'd been invited into this Discord to work with the Rockstar Union members. However, Rockstar has also pointed out that between the period of 2022 and 2025, Allsworth has also written 6 articles for the left-wing British political newspaper, The Morning Star. And it's these articles that Rockstar is referring to when the company describes him as a games journalist. These articles include one titled Grand Theft Car Crash, which Allsworth wrote in the weeks following the first delay of GTA 6, and is a short opinion piece on why he believes the industry as a whole may be in trouble because of how much is riding on the success of mega hit games like this one. The article doesn't contain any new information regarding Rockstar or Grand Theft Auto, and neither are mentioned at all in his other work. However, because of his writing for the Morning Star, Rockstar argued that Allsworth's involvement in this Discord server represented a legitimate risk for the company. Mr. Burns also made the argument that there were former employees on this Discord reading confidential information being posted by its members. To quote Charlie Kinlock's witness statement once again, he claimed there were at least 10 former employees, some now working for our competitors, present on the server when he gained access back in early October. Now, these examples have not been fully argued yet, so there's some ambiguity as to who these people were and exactly what kind of access they had to which channels on the server, for example, as well as the general channel, which much of this case is built around. There were also a set of social channels as well, which former employees were specifically allowed to access even after leaving Rockstar in order to discuss pets, music, games, and other hobbies. Again, I think this is something that will absolutely be revisited in the full hearing in much greater detail, but Rockstar is clearly making the case that some of these employees did, in fact, have the opportunity to read what had been posted in the general channel, and that represented another risk to the company's security and reputation. As for the actual reasons that Rockstar fired the 34 employees, Mr. Burns put forward that it was not actually at all to do with trade union membership or trade union activity, and let's cover each of those one by one. In terms of membership, he argued that yes, of the 34 employees, 31 of them live here in the UK and are members of the IWGB, but 3 of them live in Canada and are not members. And so the court shouldn't be able to look at this decision as firings that happened purely because of membership to this union. As for trade union activity, he argued that Rockstar had seen many more messages within this Discord as part of their investigation, including those made by people clearly labelled as active IWGB members talking about unionization, and yet those people had not also been fired. And so it wouldn't be fair for the court to rule that, simply discussing trade union activity was the primary reason for all of these people having been terminated. Instead, Mr. Burns offered that the legitimate reasons for these firings having taken place came down simply to breach of contract, which yesterday we heard Lord Hendy dispute some of the evidence that had been put forward in support of that. But today I thought it was really interesting that Mr. Burns made some reference here to what he described as a top secret element of GTA 6 that had been discussed on this Discord that was so sensitive in nature that he didn't even feel comfortable talking about it aloud in the hearing that I've just watched, and asked the judge to read that particular bit of evidence privately instead. We're going to come back to that in just a little while. And aside from the confidential information that Rockstar alleges these employees had discussed, Mr. Burns also brought up examples of what he called disparagement, referencing posts that included the words "get fucked" when describing a decision being made by Rockstar, or descriptions of a senior Rockstar employee as a... Can I say the word on YouTube? Probably not. It's a 4-letter word that begins with the letter C. And that was today. There was some back and forth between Lord Hendy and Mr. Burns after this, and then finally the judge essentially said that she'd been given so much evidence to look through as part of these submissions that she would be unable to make a ruling today, and that will actually come in written form at some point as soon as possible. We're expecting maybe next week, but we will let you know when that happens, but it hasn't happened just yet. So although we've heard bits and pieces from the evidence that's been submitted by both parties during this preliminary hearing, we've not actually seen any of the documents ourselves. That's because there's not currently a digital copy of this stuff for the general public to view, but the courts have informed us that there is a hard copy here in Glasgow, in fact just in a building right over there, about an hour or so's drive from where we were staying in Edinburgh earlier on. I have an appointment to view this copy for myself, which I've been pre-warned may be over 1,000 pages long, but for now at least there are a few very specific sections I'm interested in reading. So let's go and have a look, shall we? Alright, I'm back home to film this bit because cameras were not allowed inside the tribunal centre, and yeah, I couldn't take any photos either as a result, but I was able to take notes, which is useful because there was closer to maybe 2,000 pages all in all. We're talking 3 gigantic binders, each one about as thick as my leg, submitted on behalf of Rockstar, and then 2 boxes that had come from the union members as well. I was able to spend a few hours reading through all this material, although it should go without saying here that despite the fact that some, actually a lot of these bundles contained things like employment contracts for each of the employees and correspondence that included near identical language in a lot of cases, and so I was able to skim through some of that more quickly. I was not able to read through the entire evidence here. Of course I wasn't. Instead, I went in with the intention of examining just a few select things that I was especially interested in, some of which has already informed earlier parts of this video. I was extremely keen to read through the many individual Discord messages that had been submitted by Rockstar specifically as proof of these employees' gross misconduct. I saw a whole range of topics being discussed here, honestly, from concerns about the work canteen, to crunch, to what the company may have planned for generative AI, to pressure relating to travelling into the office during stormy conditions up in Scotland. And yes, from time to time, I could also see examples of strong language being used as well. But as you've already heard, there was also something hidden away in these messages described as being so sensitive by Rockstar's barrister that he didn't wish to read those particular messages aloud in court, and instead asked the judge to read them privately on her own. The words top secret were even used here to describe just how sensitive in nature this stuff actually was. However, as Rockstar had not applied for any reporting restrictions to be placed upon this evidence that was then made available to me in Glasgow, I have now seen what was being referred to here. It begins with one fired employee talking about his experiences with trying to request time off at the studio. Being told they don't want more than 13 people off at one time. We're a team of 56 people, soon to be 60. Then a later message says, until the end of this year, they want no more than 5 people off at a time, apparently. Then presumably in response to a message from another employee, which I've not seen, this union member responds, absolutely no idea. They mentioned the large session we did today being difficult to do, but that was 32 players. Not sure how that was difficult. Later on, another fired union member criticizes this new policy, saying, sounds like you have multiple studios of QA testers. Surely someone can manage to organize a 32 player session and let people have their time off. Those are the messages Rockstar's barrister is referring to when he describes this top secret information being talked about in relation to an unannounced feature from a game currently in development at Rockstar. Messages he didn't wish to even utter aloud. And this is how Rockstar describes the seriousness of them in its own defense. The respondent, that's Rockstar, was also gravely concerned to discover that some of the claimants, that's the union members, had been sharing highly confidential and commercially sensitive information relating to the content and features of an unannounced online service. They discussed the specific number of online players planned for this service, a material feature of this new title, which has not yet been revealed by Rockstar. Now, if we focus on the second employee I just referenced there, the one who replied to those initial messages, I saw that there were 5 additional messages submitted as proof for her dismissal by Rockstar, aside from the one you just read, and they were all in relation to the Slack policy changes we covered in our previous video. Again, it'll be up to the judge to make a decision on whether these meet the threshold of not just misconduct and breach of contract, but gross misconduct. I am wary that I'm cherry picking examples here, but I did want to focus on that particular employee because, well, she was one of 2 singled out in this way by Rockstar's barrister, Mr. Burns, because she is meant to have posted something so sensitive in nature. I thought it might be interesting to look at her case in particular. But there is one other union member I'd also like to mention because their case stood out so starkly to me as I was reading through the evidence. In most cases, Rockstar had submitted at least several Discord messages for each of the fired employees. In a few cases that had gone up as high as maybe like 20 or 30 messages. But for one of these fired employees, just one, there was a single Discord message presented as proof of their gross misconduct. And it wasn't even a long message, it was 15 words in total. So what did it say? Nothing that I've heard in North QA. We'll keep you updated if that changes, of course. Doesn't tell us a lot, does it? So I flicked through to see how Rockstar's head of publishing, Jennifer Colby, had justified this particular decision to terminate this employee in her witness statement. Here's what she had to say. The key evidence we relied upon for, I'm not going to name the employee myself here, but this employee's dismissal at Doc 76, page 613 to 614, included information about working patterns in his team. This information could indicate the stage of development that GTA 6 was at for those familiar with the games industry, and could also undermine team collaboration. And by comparison, here's how that fired employee describes the message himself in his own witness statement. On the 15th of May, I sent a message to the Discord's general channel to say that I hadn't heard anything about employees being asked to crunch in the North QA department, but that I would keep the others updated. However, I never followed up on this message. This was in response to colleagues in other departments being concerned about a rising workload. I would argue this is the only message I ever sent that was directly discussing work, and if anything, it seems to me that this would be considered the opposite of disparaging. So if the union member's statement is to be believed, he was fired for sending just one 15-word message to this Discord in which he says that as far as he knows, no crunch is currently happening in his department, and it'll let people know if that changes. Let's just read it again one more time. Nothing that I've heard in North QA. Will keep you updated if that changes, of course. Again, this is ultimately going to be up to a judge to decide whether or not that constitutes gross misconduct and is worthy of immediate dismissal with all that entailed. You'll remember from our previous reporting that employees who were fired within the office itself were then escorted out of that office by security without being able to return to their desk or speak to co-workers, and these employees had not been made aware that an investigation was underway, or indeed were not interviewed as part of that investigation. And I think this particular example, these 15 words in this message, are quite an interesting one to consider within that context. I have nothing else to say other than that. Moving on, jumping back to Scotland now, because before I left, I interviewed some of the fired union members in the direct aftermath of the preliminary hearing, but before the judge had made their ruling on the interim relief itself. As a result, there were a mixture of emotions on display. This is such a weird question. How was that for all of you?
I think the group watch party was needed, because if I'd have watched that alone, I would have anxiety, twitched myself to death, I think. But it kind of feels like, I don't know about you guys, but it feels like a breath of fresh air in a way, because someone's finally been able to say what we haven't been able to, and kind of get the story out now, our side of it. I think that's been the best bit, even though it's terrifying, a little bit.
Yeah, kind of echoing what they're saying. We've kind of just been anticipating the interim relief hearing for so long, so for it to finally come and be done with, I know we don't yet know the results or anything else, but it's good that that's what this thing was that we've been so kind of stressed about. And yeah, it was nerve-wracking, but it's just crazy, some of the stuff that's public record now, and it's getting out there, and it's probably gone further than a lot of people expected it to go, and that's a little bit relieving in a way.
Was it, I'm going to pass this to you, Jordan, was it weird to you guys were hearing your own names, you mentioned your own messages being talked about in a very formal environment, Lord Hendy would need to repeat things like the word vibes, for example, how was it personally seeing your own sort of interactions be part of that?
I think it does feel like we've been holding our breaths for 2 months, or over 2 months, and now we've finally been able to sort of breathe out. Everything that we said in a very closed environment. We never anticipated that this would, this is how we'd start the year. There is a sort of relief, either way that it goes. I think now that it's a punctuation mark at the very least, I think.
Bram, when I spoke to you last, you talked about the shame that comes with the feeling of having gross misconduct attached to your name and just being treated in that way. Is that still how you're feeling? Has that changed now that you've gone through this first part of the process?
Yeah, that feeling of shame is definitely gone, because we can now prove, hopefully, that we prove that we've done nothing wrong. What we did was for the union. I'm very happy that we reached this point, and it's out there, and people can see it. Everyone can draw their own conclusions. Everyone can see what we said. I had nothing to hide. I feel no shame about anything I did, which people can see. It was for organizing.
You mentioned Lord Hendy, and looking through kind of his history in the union movement, it's like decades long. It goes all the way back to the miners' strike. I guess, first of all, how do you feel about being represented by some of that kind of history, and also the fact that this games union struggle, which is a fairly new fight in the UK, certainly, to see it be like a part of that same history that goes all the way back to all these different unions that he's represented over the years, including like such a crucial part of like UK history.
Blown away, honestly. It feels like they brought out the A-ringer, like the top tier S+, the man that could do this. And it also feels like weirdly validating, because this man has seen this fight, he's done it for so long, he's the expert on it, and to come out and say that our fight is just as valid as all these other fights through years and years, and it's the same things that he's seen happening again and again and again. It's kind of been, like, I felt a lot better with it, I think.
Also, shout out to a 77-year-old man talking about Discord for that long. I guess the final thing I wanted to ask you about, and this may be, there'll be some different flavour of this for each of you, but just, this preliminary hearing is about interim relief. What does that mean, like, on an individual basis for each of you? How important is it? Like, what's riding on it? I can go in whatever order you like. Should I start with you? I'll start with you, Bren.
Sure. For me, it means I get to keep my home. I get to keep paying my bills, pay my mortgage, is the most important thing, because I think all of us were here in this fight, first to get our jobs back, two, to prove our innocence, but three, most importantly, to prove to everyone that it's important to have a union. Unions are there to fight for the workers, and companies can't just come along and do this. But in the last couple of days, right before the hearing, it was mentioned in the hearing as well, settlements started coming in, and then all of us were faced with the question of, well, do I put my future, my finances, my well-being, my mortgage next month, my rent next month on the front line, or do I keep fighting for what we've been fighting for this entire time and all of these years that we've been trying to unionize, to show people that unions are important and they should exist, and our industry does need to unionize. And when you're faced with that question right in front of you, you're like, okay, do I swing left, do I swing right? It's really hell to make that decision. It really is. It's really hard to stress to people how difficult it is when you're actually either one way or the other. But I think all of us here have zero regrets on the decision we've made, and I personally always wanted to see interim relief through.
It really determines how all of our lives play out over the next 6 months to a year and the immediate future, because, us not getting it, it's not the end of the world, and it doesn't, ultimately, the case isn't riding on that. It's an extraordinary remedy. But for many of us who, if we don't get it, we are going to have to just start looking for jobs tomorrow. And as we know, the games market is in hell at the moment. It doesn't like it's going to recover from that anytime soon. So a lot of it rides on, whether a lot of us stay in the games industry.
In the QA where I was working especially, it's quite hard to find a company big enough that even has its own QA department. So managing to get another job within the industry is, it's difficult for anyone, but I do think it's, particularly difficult in that instance.
It means we can keep this group together, because I rely on y'all for support a lot, because it's just me up here. Don't really have any family up here. So you guys have kind of become that a little bit. And there's the folks, like the visa folks, that I know are going to be able to stay here if they get this interim relief.
Yeah, so in our group, we have a few people who were here on visas, which were sponsored by the company. When we were fired, the company immediately informed the Home Office, which set in motion the chain of events that leads to the Home Office, issuing an order to them to leave the country within 3 months. We think they probably shouldn't have done that, because what they were supposed to do was at least wait for an appeal to come in from the employee, which they did not do. As a result, interim relief is the only way for us to like get those people the even just short-term security that they need to like figure out what will happen next with their lives. We're talking about people returning to quite dangerous countries to return to, families being heavily disrupted, if not completely torn apart, a lot of heartbreak. It's it's massive. Like my own anxieties about being able to pay my bills and looking for jobs and things like that really pale in comparison to what the visa folks are going through right now.
It's now Monday evening, a full week since the preliminary hearing first began, and the judge has just announced her ruling. In short, and to put it bluntly, she has not gone in favour of the union, and interim relief has not been granted. The judgment reads, having made a summary assessment of all the information before it, the tribunal was not persuaded that it appears likely that on determining the claims at a final hearing, the tribunal will find that the claimants were unfairly dismissed for trade union membership or trade union activities. The application for interim relief has therefore been refused. Again, this idea of likeliness is really what all of this came down to in the end. Because this wasn't the final hearing, the judge needed to make a decision based solely on the limited arguments and evidence presented over those 2 days, and ultimately make a decision as to whether she believed it was likely that in that final hearing, the ruling would go the way of the union members. This does not mean the full case has been decided yet, far from it, but as you've just heard, the immediate consequences for some of these fired employees are extremely severe. Here's how one of those affected union members described the decision in a statement that's just been sent out to the press. This decision to fail to award interim relief is a gut punch to everyone legitimately engaged in trade union activities. The real-world consequences of this are forcing valuable people to leave this country, upending their families and destroying their lives, all because of the actions of a ruthless, uncaring employer's quest to crush a trade union. We'll continue to fight to clear our names, regain our jobs, and put an end to this chapter of our lives. Throughout all of this, the bonds we have made with those who are unlawfully fired have kept us all strong. The kindness, compassion, and dedication we've all shown to each other is heartwarming and a reminder that we are all fighting for workers' rights. This decision, while not in our favour, is not an exoneration of Rockstar's behaviour and actions, merely a stumbling block on the road to justice. Whereas Rockstar had the following to say in their own statement. The Glasgow Employment Tribunal has rejected the union's application for interim relief. We welcome the decision, which is consistent with Rockstar's position throughout. We regret that we were put in a position where dismissals were necessary, but we stand by our course of action as supported by the outcome of this hearing. We will continue to report on this story all the way up to that final hearing and ultimately continue to question this decision to treat 34 employees in this way. Rockstar has undoubtedly secured a major win here, both financially, but also when it comes to the effect this will no doubt have on the morale of the union right now, today, a union which was protesting outside the Rockstar North offices just 3 days ago. Now comes a really difficult stretch, a prolonged wait made much worse by the state of the British courts in 2026, as Rockstar, the union, and all of us watching on now need to wait for that full and final ruling as to whether or not these firings were in fact legal. We will be there when that happens, whenever that happens, and we hope you'll join us as well. If you'd like to support more of this kind of boots on the ground games journalism, please head over to patreon.com/peoplemakegames. Your support is the only reason we exist. There is a version of this story that we could have covered from home, honestly, relying on Zoom calls and press releases to piece together what's happened to these workers. But hopefully you can see the enormous difference it's made to our reporting that we've been there for ourselves when it mattered. We're a small outfit here at PMG, travelling up to Scotland twice, paying for hotels and apartments, hiring a cameraman on location, making an extra stop to Glasgow to view a hard copy of the evidence. These are all expenses that we've needed to cover. To put it bluntly, this is where your money goes. So if you believe in this kind of reporting and want to see more of it, we could absolutely use your support over at patreon.com/peoplemakegames. Thank you so much to our patrons, and thank you everyone for watching.